To have a contract, we've got to have agreement, intent, and consideration. We're on to the final element now, consideration. Consideration is the price you pay for something. Now, it's a bit of a difficult subject to get your head around because when we say it's the price you pay, it's not really about the price or the value involved, okay? But there does need to be something of value, okay? So because we're dealing with a contract, it's about a bargain. So there needs to be an exchange of value. If I just promise to give you something, that's just a promise. If I promise to give you something in return for something, if there's some form of exchange, and that exchange might be you not doing something, right? So it can be very broad. But if we have this exchange, then we have consideration. So let's think about that a little bit more deeply. So consideration is the price you pay or promise to pay, because remember, a promise is just as good, and it can take many forms. It can take the form of not doing something, agreeing not to sue someone. It can take the form of giving someone a service, undertaking an obligation, money, goods, etc. It's a very broad interpretation of price. The key again is that both parties need to provide something of value. So what we're going to concentrate on are two issues. One, consideration must move from the promisee, but not necessarily to the promisor. The other one is that consideration needs to be sufficient, but need not be adequate. So these sound very legalese, but hopefully we'll get the general idea going through them. So our case for this one is Dunlop pneumatic tyres and Selfridge. So Dunlop, as you're probably aware, is a tyre manufacturer, and what they did was they sold tyres to dealers. So Dunlop are selling tyres to the distributor. The distributor would then on-sell them to the retailer. Okay, so this is our distributor, and they're on-selling them to the retailer. And what Dunlop said to these distributors was, you have to make sure that the retailers will sell according to our prices, to our price list. Now what they're doing here is trying to maintain a price in the market. They don't want prices to be cut, okay? And the distributor actually said, yes, I'll do that. I'll make sure I get a written guarantee. Now this dealer entered into a contract with Selfridge, okay? And they undertook to abide by this price maintenance condition. So they agreed that they wouldn't sell them below the price. However, they later sold tyres below Dunlop's recommended price. So they then break this agreement and sell at a low price. As a result of selling at this low price, Dunlop tries to sue Selfridge for the breach of this agreement, of this contract with the distributor. And the court held that they couldn't. Why not? Well, because Dunlop had provided nothing to Selfridge in relation to this promise. They'd provided no consideration, right? In fact, they weren't really party to the contract, but this undertaking that they wouldn't sell below Dunlop's price was with the distributor who had provided consideration. Dunlop had provided no consideration, so therefore it wasn't enforceable. Okay, there must be consideration. So Selfridge had promised Dunlop something, so there was a promise, but in return there was nothing, so it was unenforceable. So that is what we mean by consideration must move from the promisee. Dunlop here was the promisee, right? Because Selfridge had promised something. They were the promisor, and they had promised something that moved to Dunlop, the promisee. So that meant consideration must move from the promisee. None had, so it's not enforceable. Now, one of the things here is that the consideration must move from the promisee, but it doesn't necessarily have to move back to the promisor. Okay, what does that mean? Okay, so if you wash my car, or if you do so, you promise to wash my car, I am the promisee. And then if I promise to give $50 to the Red Cross, that's good, right? That's good consideration. Value has moved from me, so consideration has moved from me, the promisee, to the Red Cross, not necessarily to the promisor, to you, okay? But the person getting value must give value somewhere. That's what this term means. Consideration must move from the promisee, but not necessarily to the promisor. The promisee is the person receiving the promise. They must provide consideration for that promise. It doesn't necessarily have to go to the promisor. So Andy promises to give his bike to Ben if Ben will donate $50 to a charity. The promisor, who is the promisor? The promisor is Andy. Who is the promisee? Is Ben. From whom does the $50 consideration? The $50 moves from the promisee. Who does it move to? The charity. It's good consideration. Our second rule is that consideration needs to be sufficient but need not be adequate. What does that mean? Well, let's look at the case of Thomas and Thomas. In this case, what we've got is an action brought by a widow against her husband's executor. So what does that mean? The husband's died, and on his deathbed he said in front of witnesses that he wanted his wife to have one of his houses for life. After his death, the executives agreed to convey a life interest in one of the houses in consideration of John's desires, provided she paid £1 per annual rent and kept the premises in good repair. Later, the executor refused to complete that transaction. So the question becomes, do you think the consideration was sufficient for this arrangement? Right? So what we've got is the estate, and we've got the widow, and they provide, an interest in a house for life, and the widow provides $1 per year. Is that sufficient? And it was held that yes, that was sufficient consideration. The judge in the case said consideration must be of value and involve benefit or detriment, which it was. So that's what we mean by consideration need not be adequate. Okay, no one questions the value because it was probably worth more than $1 a year in terms of rent for the house. So the $1 a year was what's called a peppercorn rent. It was a trivial amount of money that was being paid, but something was being paid. So the consideration was sufficient even though it wasn't adequate, even though it didn't reflect the true value, because the courts are not going to second guess what someone values. If they're happy to accept only $1 a year, then that's up to them, okay? So they want people to be able to bargain. So there needs to be some form of consideration, but it doesn't need to reflect the true value of the transaction. And so here we can see this, because the law wants people to be free to make their own choices. They rarely question whether the value is reasonable. Even the most trivial payment is sufficient. Consideration must be sufficient but need not be adequate. So there are certain cases where consideration might be insufficient, not enough. And we're going to look at 3: a vague promise, past consideration, or a promise to do something you're already legally obliged to do. These 3 will be considered insufficient consideration. So Roscola and Thomas is a classic English case. In this case, someone has bought a horse, okay, so they've done the deal. Following the completion of the contract, the buyer says to the seller, so they've just sold it, and the person who's bought it says, hey, is the horse vicious? Is the horse, I think the term was free from vice? And the seller who's just sold the horse says, yeah, the horse is fine, it's a great horse. Well, it turns out, of course, the horse is vicious, and the horse bites him, and he can't really use the horse because it's vicious. Now, the problem before the court was that the promise about the horse being vicious, so the vicious promise, the promise that it wasn't vicious occurred when? After the sale. And therefore, because it was after the sale, it was merely a promise. The person who had bought the horse, so the buyer, gave nothing in return for that promise. So there was no consideration. And this is the general rule, right? Rascola and Thomas is authority for the general rule that past consideration is insufficient. What does that mean? Well, he had paid for the horse, so he had paid consideration, but that was in the past. And what has he added for this promise? Nothing. He's already paid it. So therefore, he's given nothing, no consideration. It's insufficient consideration. Collins and Godfrey is a very similar example. Collins is been subpoenaed to attend court as a witness involving Godfrey. He was required by the court to attend as an expert witness. In fact, he never gave evidence, but he had to stand by for 6 days in case he was called. After the trial, Collins gave Godfrey an invoice to cover his time spent at court and demanded payment. And what the court held here was that Collins's promise to give evidence was not good consideration. Okay, so he was subpoenaed, right? And what a subpoena means is he had, under law, to give evidence. So the court said you had to come and give evidence. So if Godfrey had promised to pay him, so if G promises to pay, so there's a promise, what has Collins given? Right? If Godfrey promises to pay, what has Collins given? Nothing. Why nothing? Because he had a legal obligation to give evidence, and he has added nothing to that. Okay, he had to give the evidence, so he's giving nothing extra beyond what the law compelled him to do. Because of that, he had no consideration, and he couldn't get any payment that Godfrey had actually promised him. So, insufficient consideration is a prior legal obligation or a prior contractual obligation. If you're not adding anything to it, there's no consideration being given. Now, Glasbrook Brothers and Glamorgan County Council is an example of where we start to see some difference around what a legal obligation is. In this case, Glasbrook promised to pay the city council for special police protection during a strike. So what we had was a miners' strike going on, and the mine requests police protection, but they're refused, right? And so what they do instead is they go to the council and say, look, if you'll send the police up, we'll pay you. The police at the time thought, look, they don't need special protection. We'll just send a car up every now and then and they'll be fine. But Glasbrook actually wanted police to be stationed there and to look after their stuff. So they got the police up there and they stayed overnight. But then after the strike was over, they refused to pay. Why did they refuse to pay? Well, they were saying, look, the police are obliged to look after us and protect us. So therefore, they hadn't given us anything extra. They hadn't given us any consideration here. What the court found was, though, they actually had done more than what they were obliged to do, than their public duty. The police thought they only needed to go up there once or twice in a car, etc. They wouldn't have to stay there in order to protect it. So because they'd done more than what the public duty was, than what their obligation was, because they'd done more, they had offered good consideration, and so Glasbrook had to pay. So let's go through this. Insufficient consideration, a vague promise. If someone just gives you a vague promise, that's insufficient consideration. Promising to be nice, promising to stop complaining, promising to be a good student. What do these mean? There's a lack of certainty as to what the promise means. Okay? What do these terms mean? If you can't be certain about what they mean, it's not good consideration, because we really haven't had a true meeting of minds, because we really can't agree on what the term means. 2, past consideration. If the price paid was paid before the promise was made, it's past consideration and it's insufficient consideration. For example, at the end of semester, I promised to pay you $50 for your hard work. My promise is not legally enforceable because your hard work is insufficient consideration. You paid it before I made my promise. Okay, so you've added nothing, no consideration. Prior legal obligation. If the price paid by the promisee is the fulfillment of an existing legal obligation, then it's insufficient consideration. That can be a public duty, like turning up to court in the case of Collins and Godfrey, or it can be a contract that you already have. But if the promisee does something beyond their legal or contractual duty, that will be sufficient consideration, as we saw in Glasbrook Brothers and Glamorgan County Council. So one of the final things we'll look at is an exception to considerations. Sometimes you don't need a consideration. When you have a deed. A deed is a very formal contract which is called signed, sealed, and delivered before a witness. So it shows that you really did want this to have legal obligations. Contracts not in the form of a deed are simple contracts. That's why we've been dealing with simple apparent contracts throughout this particular week. Deeds, like deeds of guarantee, powers of attorney, don't need consideration. You do not need consideration for the promise in a deed. It's a very specific type of legal document that has legal implications but doesn't require consideration. Okay, that's it. If you have agreement, intent, and consideration, then it looks like you've got a contract. You've got a simple, apparent contract. In the next series, we actually start looking at whether that contract is enforceable and what's in the contract.